Good morning, everyone. The Oversight and Investigation Subcommittee will come to order. The title of today's hearing is An Examination of State Efforts to Oversee the More than $1.5 trillion Student Loan Servicing Market. I would like to make a brief comment on behalf, I believe, of the ranking member and myself. A good many persons make inquiries about attendance at hearings, and I'd like to let those who are listening know that members may not be here, they may be in other hearings, but the members do pay attention to these hearings, and they have a good sense of timing such that they can be here to ask their questions when appropriate. Without objection, the chair is authorized to declare a recess of the subcommittee at any time. Also, without objection, members of the full Financial Services Committee who are not members of this subcommittee may participate in today's hearing for the purposes of making an opening statement and questioning witnesses. The chair now recognizes himself for 4 minutes for an opening statement. Section 1035 of the Consumer Financial Protection Act of 2010 established a student loan ombudsman within the Consumer Bureau to provide timely assistance to borrowers, compile and analyze data on borrower complaints, and prepare an annual report. Despite this statutory mandate, the Consumer Bureau has not issued an annual report on student loan complaints since October 2017. The position of student loan ombudsman has been vacant since Seth Fortman resigned in August of 2018, asserting in his letter of resignation that the Consumer Bureau has abandoned the very consumers it is tasked with protecting. According to the Federal Reserve, Americans owe over $1.5 trillion in student loan debt, an increase of over $100 billion since 2017. Students graduating from a four-year college in 2016 owed, on average, $29,650 each in student loans. Those pursuing professional degrees or graduate studies can expect to amass student loans in the hundreds of thousands of dollars. The macroeconomic impact of such a massive debt burden are quantifiable and ought to be a resounding wake-up call to everyone within the sound of my voice. Federal data shows that rising student loan debt is to blame for a decline in home ownership among individuals ages 24 to 32. In addition to often becoming a roadblock to the American dream, student loan debt creates significant financial hardships, and the costs only multiply once a borrower falls behind on payments, resulting in lower credit scores, higher cost of credit, and a loss of access to numerous federal benefits. To facilitate borrower repayment, the U.S. government relies on student loan servicers. These servicers are for-profit financial service providers hired at taxpayers' expense. Servicers are charged with processing payments, keeping records, communicating with borrowers, and providing counseling on repayment options. But the research shows that borrowers face dramatically different financial outcomes solely due to which servicer the government assigns to them. It seems to be that the luck of the draw can make a difference in one's life. What's worse, recent investigations by the Government Accountability Office, the Inspector General of the Department of Education, the Consumer Financial Protection Bureau, and numerous state law enforcement agencies reveal a disturbing picture of an industry that is rife with misconduct, errors, and negligence that become a monetary cost to the borrowers. Far beyond the occasional improperly imposed late fee, too often these upstream servicing failures are the precursor to preventable defaults. As a result, the data show that borrowers of color experience worse financial outcomes, including higher default rates than other student loan borrowers. Black and Latino borrowers also have higher rates of late repayment of student loans than white borrowers, 49%, 41%, and 32% respectively. Through the voices of today's witnesses, we will learn more about this powerful, unaccountable industry that is financed by lucrative government contracts and gain insights into the lasting financial injuries that misleading and dishonest loan servicing practices cause to borrowers. At this time, I will now yield 4 minutes to the ranking member, Mr. Barr.
Good morning, and first I want to thank Chairman Green for holding a hearing on such an important topic. The growth of student loan debt is indeed a crisis in our country, and according to the Institute for College Access and Success, the class of 2018 averaged almost $30,000 in debt per student. And many students have taken on debt that far exceeds that figure, sometimes reaching as high as several $100,000. Recently, a constituent came to my office, and she was a resident. She had borrowed through college, through medical school, and through residency. And along with her new husband, together in the aggregate, their student loans were reaching $1 million. And I'm sure we've all heard from constituents who are dealing with student debt by postponing things like marriage and buying a home. So this is a complex problem, and we cannot address the higher ed crisis without an honest conversation about the causes. Since 2010, when President Obama nationalized the student lending industry, the Department of Education has become the largest consumer lender in our country. New loans are disbursed faster than outstanding loans are being repaid. And student loan debt has reached an all-time high of $1.5 trillion. The number of federal borrowers since the government's takeover is up 51%. A significant portion of that debt is at risk of default. And because Democrats nationalized student lending back in 2010, taxpayers are left holding the bag. Now, as a result of the government takeover of student loans, the government owns or guarantees 93% of all outstanding student loans. So we must address major issues facing the current system. There are currently no underwriting standards to measure the level of risk for student loans. The federal government must become a more responsible lender, and schools must be honest about the cost and the value of their degrees so that students can make decisions that will set them up for long-term success. Schools that help students graduate with high-quality career prospects and low debt should be rewarded. And students must have access to data and advice that will help them to be responsible consumers of education. We are here today to address a small aspect of the student loan system, loan servicing companies. I think these companies would be the first to admit that they should always strive to do better with respect to advising student borrowers of all their options. But for the most part, these companies are simply abiding by the terms of their contracts with the Department of Education. The servicers do not set the terms of the loan. The servicers do not set interest rates for the loan. The servicers do not even choose which loans they service. All those decisions are made by the federal government. The servicers are simply contractors. They perform functions that are specifically enumerated in their contracts with the Department of Education. So if we want them to behave differently, then we need to focus our energy on adjusting the company's relationship with the federal government by reconsidering the terms of their contracts. Once again, the loan servicers do not set interest rates nor loan terms. They don't advise students on how much to borrow or where to go to school. They don't set the cost of tuition. They don't help students choose their majors or decide whether to go to graduate school. If we're going to talk about the growth of student debt in this country, then those are the issues we need to discuss. We need to look at the student debt crisis holistically, and that means working with the committees of jurisdiction in Congress and the administration to identify meaningful reforms. This is not an issue that can be addressed solely at the federal level. Steps must also be taken by the schools and states to combat rising tuition costs. It should be no surprise to anybody that when the federal government intervenes with mass subsidization, that cost runs out of control. What you subsidize is what you get, and we are getting a lot more debt because the government is subsidizing it. I welcome our witnesses and thank them for appearing today and for all their work in this area. I yield back.
Thank you. I will now extend a warm welcome to each of our witnesses, and I am pleased to introduce to the subcommittee at this time Ms. Joanna DeMarcus, who is the Massachusetts Legal Assistance Corporation Racial Justice Fellow at the National Consumer Law Center, Joe Sanders, Student Loan Ombudsman and Supervising Attorney in the Consumer Fraud Bureau of the Illinois Attorney General's Office. Nicholas Smith is an Assistant Director for Consumer Financial Protection and Senior Deputy Attorney General in the Office of Attorney General of Pennsylvania. Arwen Thurman, the Director of Student Loan Assistance Unit in the Massachusetts Attorney General's Office. And Scott Buchanan is Executive Director of the Student Loan Servicing Alliance. I'd like to welcome all of you and thank you for being here. The witnesses will be recognized for 5 minutes each to give an oral presentation of your testimony. And without objection, the witnesses' written statements will be made a part of the record. Once the witnesses finish their testimony, each member of the subcommittee will have 5 minutes within which to ask questions. On your table are 3 lights. Green means go. Yellow is the 1-minute marker, which means that you're running out of time. And red means you're out of time. The microphones are quite sensitive, so please make sure you speak directly into them. The witnesses' opening statements will begin now, and we will start with Ms. DeMarcus. You are now recognized for 5 minutes to present your opening statement.
Chairman Green, Ranking Member Barr, and members of the committee, the National Consumer Law Center thanks you for giving us this opportunity to testify today. Through our Student Loan Borrower Assistance Project, my colleagues and I represent individual clients and also train and support attorneys who represent student loan borrowers nationwide. We offer this testimony on behalf of NCLC's low-income clients because there's never been a more important time to focus on student loan servicing. In this country, student loan debt affects people at every age and stage of life. More education is supposed to translate into more opportunities, but students who take on debt to afford that education may struggle to realize that promise. These borrowers need the help of a competent and efficient servicer. Too often, however, borrowers languish in distress, struggle to make ends meet, and wait to pursue life goals while paying unaffordable student loan bills. Many unnecessarily experience the perils of otherwise preventable defaults because they do not receive the high-quality, timely assistance that could have made a difference. This is a well-documented problem. The largest servicers of federal student loans have a history of widespread servicing failures that create obstacles to repayment, raise costs, cause distress, and drive borrowers to default. Despite clear benefits to the financial health of borrowers and their families, many eligible borrowers are not enrolled on income-driven repayment or IDR plans. On these plans, borrowers may make small or even $0 monthly payments. IDR is a sustainable option that provides a path to forgiveness of any remaining balance after 20 or 25 years. Instead of IDR, however, servicers steer many borrowers into forbearances and deferments. These options are profitable for servicers and costly for borrowers. An NCLC client had this experience as she struggled to make her student loan payments after completing a medical assistant program at a for-profit school in Massachusetts. For 5 years, she dutifully contacted her servicer and submitted documentation of her finances. Despite clear eligibility for a $0 IDR payment, she was never enrolled in an IDR plan. Instead, each year, her servicer directed her into some kind of forbearance. When this borrower came to NCLC, she'd never even heard of IDR options. Though she was still in good standing on her loans during that time, she would have been better off on IDR. She would have earned credit toward eventual loan forgiveness and been spared the additional interest capitalization that resulted from each forbearance. The worst part of this story is that our client's experience is far from unique. State enforcement actions targeted at this type of misbehavior derive from similar stories. Several state attorneys general, including those represented here today, have sued servicers for these and other failures related to IDR. Student loan servicing oversight is imperative because the stakes are so high for all borrowers, and racial disparities in student loan outcomes reveal particular harms to borrowers of color. With less wealth than their white peers, Black students are more likely than other racial groups to borrow and to borrow more for their education. Research shows that Black and Latinx borrowers experience higher rate of default than Black borrowers. Upon default, borrowers can face devastatingly powerful debt collection activity. Effective servicing is supposed to be a bulwark against default and its consequences. Fairness and justice require that borrowers have the ability to enforce their rights when breached by servicers. Yet few borrowers have the ability to seek redress when servicers violate their rights. Robust public enforcement at the state and federal levels is necessary to provide relief to borrowers harmed by systemic servicer misconduct and to prevent future harms. The states have stepped up to protect their residents. Now borrowers need and deserve to have the federal government provide stronger oversight and for servicers to provide better assistance. Thank you for the opportunity to testify today. I look forward to your questions.
Thank you, Ms. Darkus. Mr. Sanders, you're now recognized for 5 minutes for your opening statement.
Chairman Green and Ranking Member Barr, thank you for the subcommittee's interest in the important topic of student loan servicing, and thank you for inviting me to testify. As we heard from Joanna, student loan debt has increased exponentially over the last 10 years, and many students are struggling with repayment. Student loan servicers are among the companies tasked with assisting students in identifying appropriate repayment options, among other functions. In recent years, state attorneys general have investigated and brought enforcement actions against multiple student loan servicers. My office conducted an investigation of Navient Corporation, one of the largest student loan servicers. The investigation revealed a plethora of student loan servicing abuses, including a deceptive practice referred to as forbearance steering. Our office reviewed hundreds of phone calls between Navient representatives and students. That review revealed that when students who were behind on their payments contacted Navient for assistance, the company steered them into successive forbearances that increased the overall cost of their loans, instead of telling students about other repayment options that may have been more appropriate, such as income-driven repayment. We found that Navient used an incentive compensation plan to pay employees more for shorter call times, thereby reducing the company's cost. For borrowers, though, short calls often mean that they are put into the wrong repayment plan. Forbearances are a temporary pause in payments that can be set up in minutes over the phone. They are not beneficial for borrowers if continued over the long term, though, because interest continues to accrue and can be added to the principal balance of the loan. Income-driven repayment plans, by contrast, are relatively complex, and it takes time to analyze whether borrowers qualify. These plans, however, offer affordable monthly payments and ultimately lead to loan forgiveness. A former Navient employee gave us a view of forbearance steering from inside the company. He described feeling pressured to reduce call time, often getting pulled aside and talked to because his calls were too long when he took the time to see if borrowers' payments could be reduced. Our office sued Navient in January of 2017, alleging that these issues, among others, constituted unfair and deceptive practices pursuant to the Illinois Consumer Fraud Act. Navient moved to dismiss our lawsuit. Navient's primary argument in its motion to dismiss our case and other state law enforcement actions is that state laws outlawing consumer fraud are preempted by the Higher Education Act. Many courts have rejected this argument. Indeed, in every state law enforcement action where a court has ruled on a motion to dismiss filed by Navient, the state has prevailed. There have been some federal court decisions, however, finding that these types of consumer fraud claims are preempted by the Higher Education Act. The Department of Education developed a set of servicing standards to protect students from these type of abuses. In April 2017, however, the department withdrew those protections. Illinois, thankfully, also took action to protect our student loan borrowers. Our state passed the Student Loan Servicing Rights Act, which went into effect this year. The act provides an array of protections for students. It restricts forbearance steering, requires that student loan servicers first offer income-driven repayment options to struggling borrowers, and requires servicers to create repayment specialists who are specifically trained to assess financial circumstances in order to effectively counsel students. The act also creates a student loan ombudsman tasked with developing outreach efforts and responding to complaints. I was appointed to serve as ombudsman this year, and through May, I have received over 300 complaints and over 200 calls related to student loans. What I have seen is that borrowers lack basic information about their loans and options. Many are unaware whether their loans are federal or private, and many are unaware of the existence of income-driven repayment plans. Borrowers continue to struggle with servicing abuses and need increased protections. Servicing failures like these create more problems for student loan borrowers as predatory companies seek to fill this information void. For example, servicers' failure to provide accurate information on repayment options has contributed to some schools engaging consultants to push students into forbearance in order to keep the school's cohort default rate down. If too many students default on their federal loans within the first 3 years of repayment, schools may lose their ability to participate in federal student aid. To keep defaults down, some schools hire companies that encourage students with delinquent loans to enter forbearance. As the GAO recently reported, these companies often push students into forbearance instead of other, more beneficial plans like income-driven repayment. In conclusion, if student loan servicers were providing proper repayment information to student loan borrowers in need, these scams would not have victims to take advantage of. Thank you for your attention to this topic. I look forward to answering any questions.
Thank you, Mr. Sanders. Mr. Smith, you are now recognized for 5 minutes for your opening statement.
Chairman Green, Ranking Member Barr, members of the committee, thank you for inviting me to testify today. My name is Nicholas Smith, and I am a Senior Deputy Attorney General from Pennsylvania. In July 2017, Attorney General Josh Shapiro established the office's first ever Consumer Financial Protection Unit and hired me to lead it. General Shapiro tasked us with focusing special attention on for-profit colleges and student loan servicers because the student loan debt crisis touches nearly every resident of our Commonwealth. The average student loan debt for new graduates in Pennsylvania is nearly $37,000, second most in the country. About 2 million Pennsylvanians, almost 1 in 5 adults, have student debt. This committee is right to focus its attention on the crisis in student loan servicing because the government contractors that service federal loans have caused needless financial harm to millions of families across the country. They have failed to carry out the programs Congress created to give borrowers more affordable payment plans for their loans. My testimony will focus on one particular servicer of federal loans, Navient, which has 1,000 employees in Pennsylvania. Our office sued Navient in 2017. The CFPB and 4 other states have also sued Navient. Our 9-count complaint is linked in my written testimony. Among other things, we allege that Navient's deceptive practices and predatory conduct harmed student borrowers and put their own profits ahead of the interests of millions of families across Pennsylvania and the country who are struggling to repay student loans. Navient's conduct cost borrowers an additional $4 billion in unaffordable interest that Navient added to their loan principal as a result of multiple forbearances. As you heard from Mr. Sanders and Ms. Darkus, income-driven repayment plans are generally a much better option than forbearance. Borrowers who enroll in forbearance face significant costs, including accumulation of unpaid interest, which is added to the loan's principal balance at the end of the forbearance, missing out on low or $0 payments that could count towards loan forgiveness, and the borrower's monthly payment can dramatically increase after the forbearance period ends. We allege in our complaint that during the 5 years from January 2010 to March 2015, Navient enrolled over 1.5 million borrowers into 2 or more consecutive forbearances. Navient's own numbers show that these consecutive and unnecessary forbearances added nearly $4 billion in interest, which works out to an average of $2,700 per borrower from forbearances. As alleged in our complaint, Navient's and its agents were incentivized to push forbearances instead of IDR because it was faster and more profitable for Navient, even though it unfairly penalized borrowers. Forbearances get the borrower off the phone quickly without any paperwork and allow the Navient agent to move on to the next call. In short, an entire generation is being held back by the shackles of student loan debt, and these debts are growing instead of shrinking, in part because Navient is not helping borrowers enroll in the payment plans that are best for them, despite representing that it is the expert in the area and would assist borrowers. For borrowers facing financial hardship, IDR plans are generally much better. It's Navient's job to help borrowers figure out which repayment plan is best for them. But despite publicly assuring borrowers that it will help them identify and enroll in an affordable, appropriate repayment plan, Navient has routinely steered borrowers experiencing long-term financial hardship into forbearance. I'll illustrate how IDR works with an example. Imagine a family with a federal loan balance of $40,000 with an income of $63,000 a year. This family would pay $403 per month on their federal loans for 10 years under the standard repayment plan. Under an IDR plan, that family would pay half of that, only $203 a month, and would qualify for forgiveness of any remaining loan balance after 20 years of payments. And if the family work in public service, such as teachers or police, they could earn forgiveness after just 10 years of those $203 a month payments. Now imagine the household income drops to $39,000. All of a sudden, this family is eligible for $0 monthly payments under IDR. These $0 payments still count towards forgiveness in 10 or 20 years. Now imagine if the family had called Navient following the income drop, and instead of IDR, as our complaint alleges, Navient steered them into a 6-month forbearance. Instead of qualifying for $0 payments and eventual forgiveness, the family will still pay nothing, but they will not receive credit toward forgiveness. Many Pennsylvanians have suffered from this steering, and we tell some of their stories in the complaint. One told us she'd worked in the public sector since 2006, qualifying her for the 10-year loan forgiveness under the Public Service Loan Forgiveness Program. However, when she asked Navient about PSLF in 2007, their employees gave her misinformation that deterred her from enrolling. She didn't find out until 7 years later that they'd given her the wrong information, and if Navient had been truthful in 2007, she may have qualified for forgiveness as soon as 2017. I thank you for the opportunity to testify today, and I would be happy to answer any questions.
Thank you, Mr. Smith. Ms. Thurman, you are now recognized for 5 minutes to present your opening statement.
Chairman Green, Ranking Member Barr, and members of the committee, thank you for inviting me to testify on state efforts to protect student loan borrowers. My name is Arwen Thoman. I am Director of the Massachusetts Attorney General's Student Loan Assistance Unit. On behalf of Attorney General Maura Healey and borrowers from Massachusetts, I appreciate the opportunity to speak on the critical issue of federal student loan servicing.
Excuse me, could you speak into the microphone? It's very hard to hear you. Thank you.
Certainly. Attorney General Healey established our Student Loan Assistance Unit in 2015. In the last fiscal year, the unit received over 3,000 hotline calls, nearly 1,000 written help requests, and generated savings and refunds of $1.5 million for student loan borrowers. Each day, we are on the front lines of the student loan crisis, helping borrowers to find more affordable repayment plans and working to move loans out of default in order to end involuntary collection activities that cause serious harm to our residents. If I can offer the committee one takeaway, it is that student loan borrowers and their families deserve much better from the federal government and the private companies hired to service federal student loans. Every day, we speak with borrowers who have found their way to our office in despair. We routinely hear that borrowers are worried about their ability to start a family, to buy a home, or achieve even a very basic, minimal standard of living. Many have been struggling with student loan debt for years, and in some cases, for decades. Each borrower's story is unique, but the patterns and their distress and their mistreatment are painfully clear. Given the social and economic vulnerabilities of many student loan borrowers, the inordinate complexity of the federal loan system, and the mounting scale of student loan debt across the nation, the role of student loan servicers is more important than ever. Although we have worked hard at the state level to improve servicer treatment of borrowers through direct advocacy and enforcement of our state's consumer laws, we believe that more federal oversight and action is necessary to protect borrowers and address the harm caused by inappropriate servicing practices. This federal oversight must not be concentrated solely in the hands of the U.S. Department of Education. which also serves as the lender and has historically turned a blind eye to many of the problems associated with student loan servicing. Effective servicing is essential to avoiding the consequences of federal loan default. Default occurs when a borrower is 270 days past due. Default carries severe penalties and can lead to many years of crushing student loan debt. When borrowers default, collection fees exceeding 20% of the loan balance are assessed. Moreover, borrowers face administrative wage garnishments, tax refund interceptions, and offsets to their Social Security and veterans benefits. Unlike nearly every other category of unsecured debt, federal student loans are generally non-dischargeable in bankruptcy, and there is no statute of limitations on collection. They can remain with the borrower for life. Here's just one example of a complaint that we received concerning a defaulted federal student loan. My wages are being garnished, but myself and my husband are living in a motel, and they are taking out too much. I am not going to be able to afford where we are staying right now. I explained that I am going to be homeless, but they said there was nothing they could do about it. The consequences of default and the long horizon on federal student loan collection create a heightened responsibility for us all to ensure that servicers are helping borrowers to successfully and affordably manage repayment. Unfortunately, we consistently see servicers that fail to provide the help that borrowers need. As detailed in my written testimony, servicing problems that we frequently encounter include failures to enroll borrowers in income-driven repayment plans that reduce payments and lessen the likelihood of spiraling debt and default, failures to help borrowers maintain the benefits of those plans through annual recertification of income, failures to provide adequate guidance so that borrowers can effectively pay down loan principal, and failures that obstruct the Public Service Loan Forgiveness Program. We have also observed the rise of predatory student loan debt relief companies that take advantage of distressed borrowers who turn to them when student loan servicers have failed to help. Congress has taken significant steps to help borrowers avoid ruinous student loan debt by creating affordable repayment plans and forgiveness programs. However, all of these programs rely on servicers. They are the gatekeepers. They are the companies contracted by the government to connect student loan borrowers with the help those borrowers need. And when servicers fail to act in borrowers' best interests, communicate effectively, or respond to questions accurately, our students and their families suffer serious consequences. We hope that you will continue in your efforts to hold student loan servicers accountable and improve servicing standards. I appreciate the opportunity to share these thoughts with you today.
Thank you, Ms. Thurman, for your testimony. Mr. Buchanan, you are now recognized for 5 minutes for your testimony.
Thank you, Chairman Green, Ranking Member Barr, and members of the subcommittee for allowing me to provide testimony today to help inform this discussion about student loan servicing. I'm Scott Buchanan, the Executive Director of the Student Loan Servicing Alliance, which represents the companies, state agencies, and nonprofits who are responsible for servicing over 95% of all student loans. It is first critical to understand what a servicer does and what a servicer does not do. Servicers are on the front lines every day of talking to and working with borrowers. We send recent graduate statements and disclosure letters. We provide online interactive web experiences, videos, and calculators. We hold Facebook chats and even Twitter parties about good repayment strategies. We provide mobile apps, and we handle tens of millions of phone calls each year. But it's also important to remember what we don't do. The federal servicers do not set the parameters for student loan eligibility. We do not set the interest rate. We do not set the repayment option requirements. We do not do debt collection, and we do not own the loans. Those are matters set forth by federal statute and regulations governing the program. Also, our role begins long after a student has chosen to take loans and exited school or graduated. While no single repayment plan or strategy is best, both financially and in desirability for all borrowers, we have delivered some pretty impressive results. We have increased enrollment rates in IDR plans by 400% since 2013. Half of the direct loan portfolio is now in an income-driven plan. While they were always low, complaints about student loan servicing declined by nearly 50% last year, according to the CFPB, and represented just 0.6% of all consumer financial complaints. And we've done all this while the number of borrowers has grown by 40% in the last decade alone. It's probably also useful to address some other assertions or rhetoric that has been part of this dialogue. There has been much mischaracterization of the recent OIG report on student loan servicing, yet there are important facts that are clear in that report. The OIG report validated that every federal loan servicer exceeded the service level agreement standards set by the Department of Education. The report shows also that federal loan servicers had an average real error rate of 0.49%. And the report shows that the Department of Education conducts extensive on-site visits, monitors service levels, and samples call recordings to validate the quality of service. Now, while I'm not party or privy to the ongoing state legal matters that may have been discussed, there are some key points that should be considered relevant to this topic. The federal student loan program is just that, a clearly federal program that is preempted from state efforts which would create conflicting requirements. Setting aside those discretely legal matters, this means servicers are now stuck in the middle between a government disagreement between the states, multiple federal agencies, and Congress. That conflict between others means that the resources we otherwise devote to helping borrowers access their options are being misdirected to try and get clarity. Most importantly, though, what can we do to improve servicing? Number one, education. We have supported partnerships with the states that help us educate borrowers, and that may mean expanding their existing higher education authorities or creating a student loan ombudsman's office who can take complaints and often offer independent third-party counsel. Two, simplification. Many borrowers face the challenge of an antiquated process to handle applications for many repayment plans, especially for IDR. We would like to work with Congress to allow data sharing between the Department of Education and the IRS to reduce borrower paperwork. Further, we welcome support to help us get permission to implement simple modernizations to let us use pre-filled recertification forms electronically for IDR, which has proven to nearly triple the response rate for renewals. Three, standardization. We continue to advocate for a common servicing manual that could be developed in partnership with ED and other regulators. Additionally, we have been actively helping to support an effort to standardize and modernize credit bureau reporting to help borrowers. And finally, protection. We have also actively been supporting efforts to pass legislation to crack down on debt relief firms that scam borrowers. We would love to partner with the states and others on this fight. Thank you, and I look forward to your questions and also working with you and others on these important issues.
Thank you, Mr. Buchanan. The chair will now recognize the gentlewoman from Ohio, Ms. Beatty, who is also the chair of the Subcommittee on Diversity and Inclusion. Ms. Beatty, you are recognized for 5 minutes.
First of all, thank you, Mr. Chairman, for hosting this committee meeting this morning. And let me just say to not only the witnesses, thank you for being here, but Mr. Chairman, I could not help but notice the audience behind our witnesses. This, since I've been on this committee, is without a doubt the youngest looking, I don't want to make any assumptions, average age that we've had to fill this hearing room. So I think that speaks volumes of the importance of this. And I want to thank all of those millennials who are here, because I'm making the assumption that you either have student loans or you're interested, and you're nodding. So let the record show that they are here because they are part of this wonderful America, and they too applaud you and are interested in this topic. Let me just very briefly say this is very important to me. And I'm really pleased that we're talking about something that is so important to not only you as young folks, not only to educators, but it is important as we look at housing, as we look at debt, as we look at financial credit scores, because debt, regardless of where you get it from, affects everything. And when we talk about education, the numbers that are on the board in this room are so alarming to me. So I'm going to be very critical of this administration. I'm going to be very critical of this Secretary of Education. And while I may not be an expert, I want the record to know that I have served as an academic advisor, I've served as a college administrator, and at one time as an advisor to young college students, I developed the curriculum at that time for the largest two-year college in the state of Ohio, which is the state I'm from, on college survival skills. And even then, one of the things that we frequently heard was, how do we pay back our student loan? Here we are now, some 3 decades later, still dealing with this issue. And I say shame on this administration, shame on this Secretary of Education. I was critical when the appointment came. I think when you're talking about our future, you need to make sure that you have someone who has worked in education, who understands all of the principles of it. So with that, let me pose my first question to the panel. It's my belief that most Americans who have to take out student loans to fund their education, first of all, want to pay those loans back. And many want to do it as quickly and as efficiently as possible, but we've not been able to do that. So who are the borrowers relying on to get information regarding their loans in is this government under this administration setting them up for failure? There's lack of information on the Education Department's website. The Department of Treasury has even criticized the Department of Education's lack of oversight. So to the panelists, are they being set up for failure? Who do they go to for information? Okay, we'll start with you, Mr. Smith and Ms. Darkus.
Borrowers are utterly dependent on the contractors, on the student loan servicers. The servicers make representations that they will help borrowers identify their options, and the servicers are failing in widespread ways at this point.
Okay, Ms. Darkus. Failing, succeeding, whose fault is this?
That's right. We pay servicers billions of dollars to do the job right. They compete for these lucrative contracts. They say that they're the experts. They claim that they can accomplish the task, but student-borrower outcomes belie those claims.
Okay. Mr. Backus, Ms. Thomas, quickly, because I have about 25 seconds.
Sure. Well,
Failing or not?
I think if you look at the actual metrics that I talked about, we are improving
I'm
dramatically.
going to rush you. Failing or not?
Not. We're working better
Ms. Thomas.
every day.
Failing.
Okay. Mr. Sanders, you highlighted something great in the state of Illinois. Should we use that same thing here in the federal government? Would it be helpful?
Absolutely. I think that the protections that we've instituted in Illinois would be helpful for borrowers nationwide. And I know that there is legislation that's been introduced in the Senate that would institute some of those same protections on the federal level.
Okay, thank you. And I yield back.
The gentlelady's time has expired. The chair will now recognize the gentleman from Kentucky, Mr. Barr, who is the ranking member of the subcommittee, for 5 minutes.
Thank you, Mr. Chairman, and again, thanks for holding this important hearing, and thank you to my friend from Ohio for recognizing so many young faces out there. I do think it's unconscionable, the level of debt that so many young people today have to deal with. It's deferring home ownership, it's deferring marriage, it's deferring retirement savings, it's producing a savings crisis in this country, and it's unfortunate that federal policy is enticing so many students to take on too much debt, especially with the degrees and the income that can be produced for repayment. I think that's something that we all have to really assess as policymakers. Mr. Buchanan, since 2010, when President Obama nationalized the student loan system, the Department of Education has become the largest consumer lender in the country. Your association is made up of student loan servicers whom are contracted by the Department of Education to ensure borrowers repay those loans. There seems to be some confusion as to the role of servicing companies in the $1.5 trillion student debt crisis, and I'm hoping you can help me clear up the confusion. Do student loan servicers advise students as to which school to attend or which degree to pursue?
We do not.
Do student loan servicers set tuition rates?
We do not.
Do student loan servicers advise a student as to how much money to borrow?
We do not.
Do student loan servicers set the terms of the loan?
We do not.
Do student loan servicers set the interest rate for the loan?
We do not.
Do student loan servicers create the forbearance or deferment option that is available to students?
We do not.
And who did create the forbearance option?
Congress did.
Thank you. So it sounds like all the factors that are driving the growth in total student debt in this country, things like lack of information available to students entering college, high tuition rates, low graduation rates, not to mention the interest rate in terms of the loan, those are all set long before the borrower even makes contact with a loan servicing company.
That is correct.
Now, Mrs. Darkus made, I think, an important point. She talked about this forbearance, and all of the witnesses are talking about this forbearance or deferment option. As I recall, Ms. Darkus's testimony was that forbearance and deferment is a profitable option for the servicers. I want to explore that a little bit with you, Mr. Buchanan. Do student loan servicers make more money? Are they more profitable by placing students into forbearance status?
We are paid far less for any borrower that's in a forbearance status. In fact, the numbers are clear. So we are paid on a monthly basis $1.05 to service a borrower who's in forbearance. We are paid $2.85 for a borrower who's in a repayment plan.
So you're paid less if the student goes into forbearance?
That is correct.
So if student loan servicers have no financial incentive to move students into forbearance status, why are so many students moving into forbearance status?
Well, the rates of forbearance utilization have declined over the last few years. Right now, approximately 10 or 11% of borrowers utilize forbearance. But it's important to understand what forbearance is used for many times. When someone applies, for example, for an income-based repayment plan and that borrower is already delinquent on their accounts, many servicers apply a forbearance in order to bring that borrower current, which is useful to that borrower because if we do not use the forbearance, they will come delinquent and get credit bureau reports.
And again, Congress created that option. The
That is correct.
servicing industry did not. Mr. Smith, is it Mr. Smith?
Yes.
Mr. Smith, I appreciated your testimony that borrowers facing financial hardship, often income-driven repayment plans are generally much better than multiple forbearances. I couldn't agree with you more. Repaying the loan instead of forbearance makes a whole lot of sense to me, especially if you can. Obviously, a lot of these students are facing financial hardship. My question to you is, since your office sued because of this issue, this problem, should Congress reform the federal student loan program to repeal the forbearance option?
That's an interesting question. We haven't given it thought, and I think it would be impractical for the reason that Mr. Buchanan explained, that forbearance
Impractical.
is sometimes used to help people when they're delinquent and getting into IDR.
Right, so it's helpful. So you're saying Congress shouldn't mandate IDR?
I think that it would be helpful if IDR were the default option. In other words, if there were easier steps to getting people into IDR, and I think Congress should explore prohibiting multiple consecutive forbearances, which is the significant harm that we found and that we talk about in our
My time has expired, but I appreciate the recognition that IDR is better, but that Congress is really the responsible party here. I yield back.
Gentleman's time has expired. The gentleman from Massachusetts, Mr. Lynch, is recognized for 5 minutes.
Thank you, Mr. Chairman, and to the ranking member. I want to thank the witnesses for your testimony this morning. Very helpful. Mr. Chairman, I ask unanimous consent that I might enter into the record the complaint in the case of Commonwealth of Massachusetts plaintiff versus Pennsylvania Higher Education Assistance Agency doing business as Federal Loan Servicing.
Without objection, it's entered into the record.
Mr. Chairman, the complaint here lists a litany of abuses by this particular servicer that have been recounted in the testimony of our witnesses this morning, varying from not informing students that there was an income-related repayment option. In some cases, students were not made aware that their public service entitled them to a more favorable loan repayment schedule. Ms. Darkus, so we're dealing with this whole situation, and it is so varied and so widespread, as Ms. Thoman has laid out as well. Would it be a cleaner solution for Congress just to impose fiduciary duty on the part of the servicers so that they have to act in the best interest of the student who takes the loan out? That would seem to get at all of this rather than trying to do it piecemeal, trying to create incentives for the servicers to treat people more fairly.
That would be a powerful accountability tool. Many borrowers are unable to speak up for themselves because their relationship with the servicer is indirect. They don't choose their servicer, they don't choose the terms of their servicing, and they don't have a contract with their servicer that they can then try to enforce when the servicer violates their right. Creating a duty that requires the servicer to affirmatively act on behalf and be responsible for borrower outcomes could be very powerful.
Thank you. Ms. Thulman, I know that you're involved in, and I thank you for your good work, and also Attorney General Healy in my state of Massachusetts doing terrific work on this. Is that something that, I mean, you've seen, at least in the complaint, it talks about the shifting irresponsibility on the part of some of these services. When you nail them down on one aspect of it, they seem to create a new and different type of abuse that they employ. Would creating this fiduciary duty that requires the servicer to act in the best interest of the student who takes the loan out, would that be helpful in relation to the cases that you continue to see in Massachusetts?
Yes, I absolutely believe that creating a fiduciary duty for student loan servicers would be helpful. It would also need to come with a means for borrowers to enforce that obligation.
Right. Well, I mean, there's plenty of case law that articulates what you know, a responsible fiduciary must do, so they would be measured by that standard. Are there any other recommendations that you would like to see in terms of protecting some of these students? You know, I've got nieces and nephews that are, you know, up to their eyeballs in student debt, and it's unbelievable, you know, the amount of debt that some of these kids are carrying, and we got to figure out a better way, because they're just you have to put your life on hold. You can't start a family. In many cases, they're, you know, still living at home with their parents. It's just it's very depressing and a heavy burden on these kids. Is there something else we could be doing here that might lift that burden?
I think that part of what we're all saying here is that Congress has done a lot to try to lift that burden by creating these income-driven repayment plans and public service loan forgiveness programs. I do think that those programs could in many cases be more generous towards borrowers. You know, we could raise the amount of income that is protected so that we're not looking at 150% of the federal poverty line, which I think for a single borrower in Massachusetts is less than $20,000.
Right.
The student loan servicers are also, you know, not wrong that the system is very complicated. And so to the extent we can do things to streamline, to make recertification simpler, you know, but I do think that in large part a framework has been created to address many of these problems, and that implementation of that framework has been very challenging for the servicers.
Okay. Mr. Chairman, my time has expired. I yield back. Thank you.
Gentleman's time has expired. The gentleman from Florida, Mr. Posey, is recognized for 5 minutes.
Thank you, Mr. Chairman, for holding this committee meeting. Mr. Buchanan, how many federal loan repayment plans are there today?
Well, that's a complicated question, because for every borrower, the amount of repayment plans that they have eligibility for varies based upon when they took out those loans, what year they graduated, and when Congress gives and takes away repayment plans. But in all in, including forbearances, deferments, 5 different flavors of income-based repayment, there are more than 55 repayment options that are available to any given borrower at a particular time. And so, as I said, some borrowers may not have access to all of them, and that's the complexity of the federal student loan program. If you ask what particular borrower has access to what loan repayment options, there's a whole laundry list of questions that have to be asked and assessed before you could even determine which of those 55 are on the short list of things they could turn to.
Do any of the applications for the loans ask the student how they plan to repay them?
In the master promissory note, I'm not familiar. I'd have to look at that's on the front end, which is the Department of Education originates these loans and is the lender. So they handle all the loan disclosure up front for originating the loans. But to my knowledge, I don't know that that's specifically called out, but I could be wrong.
If a student wanted to pursue a PhD in primitive basket weaving, where along the process would somebody tell them that it's highly unlikely they'd be able to repay the loan?
Well, one would hope that that communication came before choosing to take that degree and moving forward. That's really an opportunity for, and again, this is not an area that we're involved because this all happens long before the borrower comes to us. They've already made those choices and decisions and have gotten and hopefully graduated into the job marketplace. But that's probably where, from a front-end perspective, as the lender, the government should look at what is its level of disclosure and communication to a borrower. Schools should probably be playing a role in that conversation. And I think that's also a great opportunity for states and others to participate with individuals in their jurisdictions and be part of that education process. At the end of the day, I think what we're all trying to do is help people make informed and better decisions, right? And we'd love them to make informed, better decisions before they came to the servicing side, where we have to, in essence, deal with those choices that have been made and try to put them on the best path that is available under the federal law. But I think working together, whether it's Congress, schools, Department of Education, and states, and families, on being informed about making good decisions before they take on debt, I think that would be very helpful.
Well, does anyone know where it's mandated that the various parties that Mr. Buchanan mentioned are actually obligated to help students make intelligent decisions about how much they're going to borrow and be able to repay?
I don't believe that servicers are expected to advise borrowers about how much to borrow when they're in school. I think a lot of what we're speaking to from the borrower experience is that the cost of attending college increases in repayment due to servicer error and misconduct. I've seen borrowers who borrowed $6,000 to go to school wind up with 6 figures of debt because of servicing errors, forbearances, default, and issues with getting into income-driven repayment after years of struggling can make a balance balloon even after the initial borrowing.
So it sounds like we need to require a financial literacy test or at least a course before somebody's allowed to apply for a student loan. Mr. Chairman, I'd like to yield the remainder of my time to the ranking member.
Thank you for yielding. Mr. Buchanan, does the student loan servicing industry have any data about the risk of default when a borrower responds to servicer outreach versus when a borrower does not interface with a servicer?
Yeah, I think the data exists, and that's one of the more troubling things here, right, is this conversation. Listen, servicers, we make mistakes from time to time. You look at the statistics, and those are not at a high level at all. But when the conversation is saying avoid talking to your servicer, who are the experts, who are supposed to be working with you, that's a real problem, because if we can talk to someone who's on the cusp of default, which is the real worst thing that can happen to a borrower at the end of the day in terms of consequences, 9 out of 10 times we can get them into a repayment program or a repayment option that is going to help divert that default and get them back current.
The gentleman's time has expired. We will now move to the gentlewoman from New York, Ms. Vasquez, for 5 minutes.
Thank you, Mr. Chairman. Ms. Darcos, federal student aid began accepting and reviewing applications from borrowers seeking loan forgiveness under the Public Service Loan Forgiveness Program in the fall of 2017. As of March 31st, 2019, the Department of Education has only approved 518 of the more than 73,000 borrowers who have applied under the program and discharged only approximately $30 million in student loans. Why are these numbers so low? Why has the Department of Education not approved more borrowers for forgiveness under the Public Service Program?
We know that borrowers who are seeking public service loan forgiveness have a lot of hurdles in order to get there, and their servicer is supposed to walk them through that process. As the lawsuits that you've heard about and these witnesses can tell you more about expose, there are many ways in which servicers can thwart the efforts, the very determined efforts of public servants to fulfill their responsibilities to their community, repay their loans, and get the forgiveness they deserve. And that happens when they believe that they're on track to get forgiveness because their servicer assures them they're in the right repayment plan and that they are doing everything they need to do to comply. As you've heard today, that excuse me, there are affirmative misrepresentations made by servicers. They're not just forgetting to tell people information or saving time and eliding some of the options. They're telling people you're on track when you're not, and they're.
Thank you. Thank you. Mr. Buchanan, state attorneys general have initiated enforcement actions to protect student loan borrowers from unlawful servicing practices. Do you think those cases are without merit?
Well, listen, again, I'm not privy to the details of those cases. Those are between the attorneys general and those entities. I think so far it's clear that there have been no rulings on the facts in those cases and on the merits of those arguments. They are assertions, but there's been no determination that they're true.
Okay, thank you. Reclaiming my time. Ms. Darcos, student loan borrowers with direct loans do not choose their loan servicer. Rather, the Department of Education assigns the loan to a servicer after disbursement. Can you explain why this is the case and how this case came to be?
I think it's certainly problematic that borrowers don't have the option to vote with their feet and choose their servicers in most contexts. Yes, they're assigned a servicer, they're stuck with that servicer, and that is a problem for borrowers who are not getting the kind of service that they need. And it's also a problem because the same servicers that systematically fail those borrowers continue to get more borrowers assigned to them.
Do you believe that, do you think student loan borrowers will have better experiences with their servicer if they were able to choose their servicer and services were forced to compete for borrower business?
That's a very good idea. We are sorely lacking competition in the servicing market, and that harms borrowers.
Would you support that, Mr. Buchanan?
That's a policy choice. Congress previously did allow competition among servicing and let borrowers make those choices, but that was eliminated when Congress passed the Affordable Care Act and took over direct administration of the student loan program. So when that choice was taken away. But I think that's a conversation for Congress to determine about what is the appropriate way to give people options here. We support options and making sure that borrowers have good access to quality service, absolutely.
Mr. Buchanan, in November 2017, the Illinois Student Loan Bill of Rights became law. Will you be supportive, or do you think this is something we should be developing on the federal level?
As I talked about, I do agree that we need to have some common servicing standards, and we have long endorsed a common servicing manual that would be developed in cooperation between all the interested parties so we could get some agreement about what those standards. The real challenge is when you have those conflict at the state and federal government level, and when agencies at the federal government fight with each other about what the rules are. We sit in the middle of trying to find out what is the right way to service the loan, and we follow the guidance by the government. And so any effort to create some common standards, I think we would think is a valuable contribution to the dialogue.
The gentleman's time has expired.
Not common standard, Bill of Rights. Thank you, I yield back.
The gentlewoman's time has expired. The gentleman from Ohio, Mr. Davidson, is recognized for 5 minutes.
Thank you, Mr. Chairman. Thank you to our witnesses, and appreciate your expertise and commentary in writing and in person. There's no doubt that the student debt crisis is indeed a crisis. It is complex, and I look forward to your input in how we might go about improving the problem. Mitigating the downsides for taxpayers, but also providing the service that could be provided. You know, as we've had the dialogue, and Mr. Posey addressed earlier, that no one could answer, how do we do the underwriting? That's because the people that actually do the underwriting aren't in the room. So we're holding up the servicers as if they have a fiduciary duty when they don't actually do any of the underwriting. We don't price in the risk of default based on major, based on college or university selected, or based on aptitude. We don't base the loans on creditworthiness unless we happen to do it on a co-signed loan where the family's creditworthiness is really there. And so we keep loaning money to students regardless of these decisions. Last Congress, when it became controversial for a minor reform to the Higher Education Act, to advise people about the risk of default, and then to have some consequence for the universities that do have higher default risk. It was a deal killer because the politics were so bad. As a history major, I don't know that I favor the idea that the government picks what your major is, but certainly we shouldn't be indifferent to the default risk, particularly if we're going to hold someone to a fiduciary responsibility for the performance of the borrower in repaying that loan. Lastly, I would say in my commentary portion here that as we talk about what to do for the students, the idea that we would take out these loans with no real intent to repay them is called fraud. So we shouldn't allow or support fraud, and we shouldn't go down a path that makes it so unbearable for them to pay the debt. I just want to highlight that begins up front by knowing how much debt to take on. And so we're here only focusing on the back end. So I don't know that we're looking at the problem in a way that will holistically help us solve it. But with that, Mr. Buchanan, what can be done about the components of an interest rate risk, the time value of money and the default risk? What can servicers do about that?
Well, I appreciate this, and I appreciate all the comments, and you get into the complexities, and I know everyone's acknowledged we're not fiduciaries, but at the end of the day, I think we're trying to look out for what's the best options for borrowers, and what our real job is to say, all right, let's take your situation, let's meet you where you are, you've made choices, decisions, things have happened in your life, right? And those are complications that can impact people's ability to repay. And our job is to say, let's regularly communicate, let's stay in touch and talk about that as it changes. So I think anything we can do to increase the amount of contact that we have with a borrower, and keep in mind one of the challenges when you're managing north of 50 repayment plans is that when a borrower calls up and wants to talk to us, very seldom do they want to stay on the phone to talk through 55 repayment options. So part of our job is to do all this other disclosure along the way. That's why we have these websites and other things and calculators.
Thank you for that, reclaiming my time. The point is that these decisions have already been made. You can try to ameliorate the consequences of decisions that have already been made. And as a system, the higher education regime in the country has highly incentivized four-year degrees. And the concern I've got is this isn't always the best fit. Sometimes people don't find that that's the case until they're far along and far in debt, and now they're looking at other degrees, many of which have a better path for ability to service debt. They have better demand for employability. And I just want to commend some of the trade schools, particularly like Butler Tech, our community colleges that are there, people that are innovative in the 8th District of Ohio, offering students a path to a career and a vocation that has high employability and great chance. And I just wonder, lastly, Mr. Buchanan, how could we go about providing that upfront advice? Does the government need to do it? Do universities need to do it? Or as you alluded to, could we return to the private sector making sound underwriting decisions?
I think all of those are options, and I think this is a complicated problem, and there are no simple answers to this. And I think we have to have everyone engaged, and whether it's institutions that are being creative and innovative, talking about the value of what they're offering, whether it's about bringing families in high schools and counseling before people make decisions or look at financial aid packages, colleges and universities, the financial aid offices, continuing to do better jobs on disclosures and making transparent. Those are all things we should all be doing.
Thank you. My time has expired.
Time has expired. The chair now recognizes the gentlewoman from Michigan, Ms. Talib, for 5 minutes.
Thank you, Mr. Chairman. You're right, Mr. Buchanan, there's not really a simple answer to all of it. But however, I think what needs to be at the forefront and is simple to me is that this is people that are buying an education, not a Lamborghini, not some sort of luxurious something. You know, this is a responsible decision, I think, that they're making. May it be informed or not informed, and as a person that when you enter, you look at the tuition for a minute, but at the point is you want your bachelor's degree, you want your degree at the end. And that is really what the focus is when young people get in there. And then afterwards, they expect the government and the quasi-governmental relationship they might have with private companies to do what's in the best interest of their future. So, you know, Michigan Borrowers has some of the highest student loan debt in this country. Many residents are pulled into courts. I've talked to residents directly about this and later having to pay double what they owe due to student fees and interest rates and even attorney fees. In 2017, the CFPB sued Navient, is that how you say it? Navient, for incentivizing employees to encourage borrowers to postpone forbearances, an option where the interest rate accrued and they collected over $4 billion in interest. The Department of Education often encourages the debtor to talk to their loan servicers for advice and help. I'm a person that called, and they said, call your servicer. However, in response to the lawsuit filed, Navient, the servicers stated that in their complaint, their response to the complaint, that they don't have to provide good advice to borrowers and that they have no affirmative duty to do so. Question for you, Mr. Buchanan. The federal government spent about $700 million in 2017 on debt collections for a little fewer than 7 million borrowers in default. Navient is a member of your organization. Do you agree with the servicers that servicers have no responsibility to the borrower to give a good advice even when more than half of its account come from the Department of Education?
Well, first of all, I think servicers don't do debt collection. So the litigation and all that, you know, about borrowers, that's not something that we have any involvement with. So we serve borrowers up until the time in which they default. So I couldn't speak to sort of the debt collection component that you're talking about.
But do you think that borrower, do you believe that many of the members of your alliance have a duty or responsibility to give good advice?
So as I think folks on both sides of the aisle in the panel today talked about, there's not a legal fiduciary responsibility, but I absolutely believe.
No, it's interesting, Mr. Buchanan, because since I've only been here 5 months, and it seems like any corporation, it's like they wait for us to force them to do what's right. It's almost common, like, okay, you have to give a good advice. You're kind of you have this contract with Department of Education. Your responsibility is to help these folks that have loans and guide them through the process. I almost feel like if we don't spell it out, do what's right, this is your responsibility. It's like, for me, it's like a da moment. Like, you have to give good advice to those that are calling you and provide I don't care how long it takes. At the end, that person on the other line wants to be able to pay, you know, as close as to what they borrowed as possible, and they want that kind of advice. The question I have is for many of the attorney generals here, folks from the Attorney General's office, as well as Ms. Darkus. Yeah, thank you all for being here. One of the things I'm wondering is what other things that you are doing on the state level and the local level to push back against abusive and profit-driven practices? And, you know, what are some of the predatory practices of loan servicers and debt collectors have you seen in your state that hasn't been discussed in this hearing right now?
Speaking from Massachusetts, we have seen an inordinate number of student loan borrowers who have been victimized by for-profit schools that made false promises of employment, 90% employment rates. In many instances, we talk about underwriting standards here, but in many instances, some of the federal student loan servicers in a prior incarnation of their existence made loans to many of these students, in part because they were interested in federal student loan volume. And so, the abuse of these for-profit school borrowers and the role of these companies in creating that system is very significant and should not be overlooked.
Speaking for Pennsylvania, we have sued the U.S. Department of Education twice for the gainful employment rule and the borrower defense rule, two important rules that they are attempting to roll back. Gainful employment would have made important disclosures to borrowers up front and would have actually shut down programs where default rates were very high, so it would have gotten at some of the underwriting problems that people have been talking about. But the DeVos Department of Education is attempting to repeal those rules.
We had a committee hearing on
The gentlelady's time has expired.
Thank you, Mr. Chairman.
The gentleman from Tennessee, Mr. Rose, is recognized for 5 minutes.
Thank you, Mr. Chairman. I think an important fact that we need to keep in mind as we have this discussion today, and it is an important discussion, is that in 2011, when the federal government took over the student loan program, we did so under the false premise that over 10 years we were going to create $61 billion that we're going to take from the student loan program and use to pay for a flawed national health care plan that many of us call Obamacare. In fact, as we know, that hasn't worked out. In fact, most recent reports show that we are nearing the point where the program is actually going to cost, and clearly we've created a burgeoning student loan problem in our country. And as a small businessman and first-time elected office holder in Tennessee, this is just the sort of shenanigan that the voters in the 6th District of Tennessee are upset about when they see the performance of Congress and how, when we attempt to federalize programs like this and remove the private sector incentives to make responsible lending decisions, we create just these sorts of crises. Shifting now, several of you have testified that your agencies have brought lawsuits against federal student loan servicers for various reasons. Mr. Smith, you mentioned in your opening statement ongoing litigation. I want to make sure that I understand where we are in the process of this litigation. You're an attorney, I believe, and I'm trained as an attorney as well. And I just have a question. I guess, have things changed in this country, or are individuals and corporations presumed innocent until proven guilty in a lawsuit?
Well, in the criminal context, they're presumed innocent, yes. This is not a criminal lawsuit, but they have not been, has not been a judgment yet, sir.
But even in civil cases, the defendant is, it's the responsibility of the plaintiff to prove the case and to prove the facts of the case. Is that right?
That's correct.
Isn't it true that in the case that you made reference to, the defendant has not had their day in court to defend themselves yet?
That's right. That's why I referred to allegations in my testimony.
So your office has made allegations against a servicer. The servicer has disputed those allegations, and the court to date has not made any decision based on the facts in that case.
That's correct, but many of the things that I said were based on the facts that we know from documents that Navient has provided to us. So, for example, the $4 billion in interest, I've got the document right here that Navient provided that supports that allegation.
Has a court decision been made regarding, your statements today remain unproven allegations, and no court has determined whether or not they are true?
That's correct.
It seems to me that this is yet another example of Director Cordray's regulation by enforcement ideology, where once again the CFPB under Cordray demonstrated a proclivity for self-promotion instead of consumer protection. Mr. Smith, if the CFPB is so focused on student borrower protection, why was there no rule proposed in dealing with private student lending?
I can't speak for the CFPB.
Mr. Buchanan, given the lawsuits that are currently in process, as they have not actually made any rulings on the facts at present, what solutions are servicers proposing from your experience that will make a difference today for some of these struggling student loan borrowers?
Yeah, and as I talked about sort of in my opening statement, my written statement goes into some more detail, and I'd love to work with the committee on those things. But if you look at, there's a lot of opportunity to take the process that we have to deal with today. So the process, for example, on income-based repayment or public service loan forgiveness is dictated by the Department of Education. And we want to work with them, and we've been providing feedback pretty regularly, and that's how a lot of things actually have changed and improved. You see the IBR uptake that has increased pretty dramatically. We worked through improving the recertification process with the department, and some simple things like allowing sort of data sharing between the IRS and the Department of Education. Today, if someone wants to stay in income-driven repayment, they have to go to a separate website at the U.S. Department of Education. They have to refill out that form. They have to resubmit documentation to the IRS to ask for the same thing they asked for last year and redo all that, and that's a hurdle for us keeping people current. So those kinds of process simplifications are things that I think we all at this table hopefully could agree upon are things that we ought to be working on. It's also that. It's also making sure that we have consistent credit reporting so that when someone has an issue that they're treated properly.
Thank you, and I yield back.
The gentleman's time has expired. The gentleman from Illinois, Mr. Caston, is recognized for 5 minutes.
Thank you, Chair. Thank you to all the members. Mr. Buchanan, what's the typical servicing fee paid to your members on a given loan?
So it's for a loan that's in repayment, it's about $2.85 a month per borrower.
Is that calculated per loan volume? Is there like a percent of loan volume, or is it just per loan?
It's per borrower, not per loan, but at per borrower level.
Okay, and is it my understanding that as loans go into default, that rate falls?
That is correct. It declines. We're incentivized to keep a borrower in current repayment in one of these income-based repayment plans or standard repayment, and our compensation declines as that loan gets more and more distressed, encouraging us to keep the loan active. In fact, we talked earlier about forbearance utilization. That's paid the least of all these things relative to a loan that's right at the end.
Okay, but when they go into forbearance, you would ensure that they do not go into default. I think a lot of the people here have mentioned that putting in forbearance keeps the default rates low.
It can help, yes.
Okay, so therefore you make more money by putting people into forbearance and keeping them out of the default rate because you earn more money on your overall portfolio.
I don't think that would be the calculus that's involved in this. I mean, I think what we're trying to do is make sure, so when they're in delinquency and getting ready to default...
Sir, just if I may, I spent 16 years as a CEO. You provide incentive compensation to employees that makes you more profitable. The fact that there are incentives that are driving people to do this, and look, I got no problem with profits. Profits are a beautiful thing. They drive human behavior. The idea that there are incentives to employees to push people into forbearance and that you have no profit incentive to do that strains a little bit of credibility. I'm not saying there's not a problem there, but I'm saying we got to acknowledge if you are making more money by keeping people out of default, and if forbearance is a way to keep people out of default, let's acknowledge that. That's all I'm asking.
So the rate of forbearance is relatively low here, and it's used in general for pretty short periods of time. And I'm unaware of any servicer who provides compensation to put someone into forbearance. We try to make these calls efficient and effective, and so we can get people as quickly as possible to the best outcomes for them.
Well, let me pivot, if I could, to some of their witnesses. The challenge I have is that there's, as I said before, pursuit of profits is a wonderful motivator of human behavior. It is neither moral nor amoral, it's just pursuit of profits. The challenge we have as regulators is to try to make sure that that profit incentive is tied to the public interest. And the challenge that we have on this committee is that so often people deny that there's any conflict. That makes our job as regulators tougher. It is particularly difficult in this moment when the Secretary of Education is actively defanging it. And I am extremely proud to come from Illinois, where the efforts that you've led, Mr. Sanders, through your ombudsman, and through the Student Loan Bill of Rights, one of the best programs in the country. Can you just talk a little bit about what challenges you have in this moment with the Trump administration and Secretary DeVos culling back on obligations that are not being done federally that you have to step up and fill?
Absolutely. So, the Office of the Attorney General in Illinois has been active in the student lending space for many years. Will continue to be active going forward. I think that the big change that we've seen is that we don't have a partner on the federal level in protecting students. In many ways, we have an opponent. So instead of sharing information with state attorneys general to determine ways to help borrowers, we have the Department of Education issuing a notice of interpretation saying that states can't enforce their own laws, that they can't access the information that law enforcement needs to determine if there have been violations of our laws. And we have to spend our time fighting against the federal government. So, for example, that notice of interpretation has been discredited by several courts, but it takes our time and effort away from helping student borrowers when we have to fight roadblocks that are thrown up like that.
Would any of the rest of you from the states care to comment on what that hassle means for the burdens borne by students who are in default or former students?
It certainly delays our lawsuit. We also faced delays in getting borrower data from Navient in the context of our discovery in our lawsuit. And we had to go to our judge and ask him to force Navient to turn over the borrower data. The excuse that Navient gave was that the Federal Privacy Act prevented them from turning over the data, but that was not correct legally, and they only made that excuse because of the Department of Education telling them that they could do that.
Thank you.
Gentleman's time has expired. The chair will now recognize the gentleman from Georgia, Mr. Loudermilk.
Thank you, Mr. Chairman. Thank you all for being here. This is an interesting panel that we have here, and it's an interesting subject. However, I'd like to get to the root of the problems, and the root of the problem I see is the astronomical cost of education these days. It's unbelievably high, and I don't know that we're really addressing that situation here. We saw this in Georgia years ago. It used to be that in the university system of Georgia, they had to keep their tuition rates competitive enough that a working class family could afford to send their children to college with minimal outside support. What changed in Georgia was a public funding program to ensure every child gets a chance to go to college, and when that went through the legislature, the cost of education skyrocketed, and it's remained high ever since. I recently was speaking to a group about the need that we have for students to go into technical fields and the jobs that are available there, and after I got done speaking, a young lady came to me and she said, "Let me tell you what happened to me and my sister. We both graduated about the same time. She went to college. I decided to go into a technical field, went to technical college, graduated. Now, 4 years later, I've made more money, about the same amount of money I've made that she now has in student debt because of the cost of actually going to college." And I think our government involvement is part of the problem. While we're seeing this, it's just a natural effect. You got this free public money out there, so now we're going to go get that, and we can raise our rates. I don't think we're going to get a handle on this until we can actually do something about the astronomical cost of going to college. But with that aside, Mr. Buchanan, I know we're talking about servicing these loans here today. And from what I know about any major loan that you're taking out, when you look at the cost these students are accruing this early in their life is unbelievable. But with any other significant loan that we take off, I mean, car loans, much less than the amount you're borrowing is much less than most of these students are borrowing. There's rigorous truth in lending disclosure statements for those. There's rigorous truth in lending disclosure statements for buying a home, for commercial loans. Is there such requirements for student loans, or do these students really know what they're getting into?
Well, again, I can provide some context, having been in the higher ed space for 20 years or so on what's going on. Obviously, that's not a servicer role or function, but I think it is important for borrowers to be well educated up front. about what the consequences are of the choices that they're going to make, for good and for bad, right? College is an investment, and the idea is that we let people borrow money so they can increase their earning power over time. And when that works well, it works very well. And I think, but having people understand that, you know, the repayment plans that they're gonna select, the interest rate, all that is being set up front and fixed by statute. And then understanding that if you do take advantage, we talk a lot about income-driven repayment plans, and those can be very beneficial for some borrowers. For some borrowers, they can increase the total cost of borrowing pretty materially over the life of that loan. And that's all based upon the borrower's individual situation. And so having a borrower be disclosed what those situations could look like, I think would, listen, having an informed borrower before they make choices is always the best kind of borrower.
Do we need to do anything to ensure better disclosures for these loans?
I think, listen, I will leave, that's a policy question for the front end of lending. But I think having disclosures, and if you look to the private sector, there's a lot of disclosure that goes on there. Is there an opportunity, again, as we've talked a lot about harmonization and simplification, is there an opportunity to harmonize with what is done on the private student loan marketplace? I think that's something that ought to be looked at and considered.
Are there any requirements to assess the student's ability to repay the loans?
I'm sorry.
Is there any requirement we have to assess the ability of the borrower, the student, to their ability to repay the loan?
No, currently the federal government, when it makes loans, does not assess an ability to repay.
And I can understand part of that because if it's a student, they're usually not employed. But I also look at this, if the student is academically inclined and they're going to get a nuclear engineering degree, their likelihood of the ability to pay it back is much higher than someone who may just be getting a literary arts degree or something that may not pay as well. But we don't take any of that in consideration.
That is correct. The government does not.
All right. I yield back.
Gentleman's time has expired. The chair now recognizes the gentlewoman from Texas, Ms. Garcia, for 5 minutes.
Thank you, Mr. Chairman, and thank you so much for bringing attention to this critical crisis. And I too, like my colleague, Ms. Beatty, want to acknowledge the different look that we're getting behind the panel table. And I might add that not only is it younger, it's also absolutely more diverse. And it's good to see so many young women there watching. And I wanted to start with a little focus on that because with Ms. Darkus, you mentioned the impact of some of these practices and the default rate on African American students. And it strikes me that no mention was made of Latino students, and more importantly, too, young women, because by and large, not only are we not included, but at the end of the tunnel when we graduate, we may get hired and not get equal pay for equal work, which means our ability to repay is also diminished somewhat because of the inequities in salary and training and promotion. So do you have any data with regard to other people of color and also women?
Yes. The data are still developing. We need more information that is disaggregated by these characteristics like race and gender. But I can tell you that like Black borrowers, Latino borrowers also report higher rates of late payment. They struggle to repay in part because of the racial wealth gap. And the research also shows that Latino borrowers, like Black borrowers, experience higher rates of default. We also know that women carry about 2/3 of outstanding student loan debt. So when we're thinking about who's bearing the burden, who might be struggling in repayment, we're thinking about people of color, we're thinking about women. And that is in part because of the legacy of discrimination on the basis of race and on the basis of sex in this country, the ongoing gaps in earnings and in wealth, and we're actually seeing that student loan debt widens those gaps into chasms. So we have to be very
So you would say there is a disproportionate impact on people of color and women?
Yes.
There is. And that would be true all across America and not particular to any region or state?
Yes.
Okay, thank you. Now, I'm going to go on to Mr. Sanders, and thank you to all the representatives here from attorneys general. It's great that they're doing some good work. I just wish that my attorney general was at the table with you, but regrettably, I can't say for Texas is doing what some other states are doing. Mr. Sanders, you pointed out that the colleges sometimes engage cohorts, in their cohorts, management services companies that will steer the student to forbearance because they're concerned about the default rate in their colleges. I mean, I find that so troubling that a college or any public institution would actually try to find a group that would do that more to decrease their default rate. And could you just explain that just a little bit further? And I'm running out of time, but also why they would do it? I mean, is it they're being reviewed on the basis of that? Because obviously this is maybe another scandal in the brewing.
Happy to answer the question. It's a good one. So under federal law, if schools have too many borrowers default within the first 3 years of repayment, they could lose access to federal student aid.
But only that particular aid where the default rate is high, or all student aid?
So depending on how long the violation goes on, it could be all student aid. So with the existence of income-driven repayment plans, defaults should approach zero. There will be some borrowers that we can never reach, but with income-driven repayment, if you're not making any money, you can make a $0 payment. So everybody has the ability to qualify for these. If servicers were providing better information, schools wouldn't have to engage these low-rent consultants that only have one goal, which is to push people into forbearances.
Well, I find it very troubling, and Mr. Chairman, I'm sorry I ran out of my time, because I really think that this whole idea that colleges may be doing this just to protect their own interests is very, very troubling.
Gentlelady's time has expired. Chair now recognizes the gentleman from Wisconsin, Mr. Stile, for 5 minutes.
Thank you very much, and thank you for holding today's hearing. I'm very concerned about where we're at with student debt, but I think what we're missing sometimes is what the underlying cause is, which is the cost of the underlying product of the education. And so, Mr. Sanders, you mentioned at the beginning of your testimony today that students are often unaware of the basics of the loans that they're taking. And Mr. Smith, you noted that Pennsylvania has the second highest student debt in the nation. I think that's very telling. Do you know what the cost is for an in-state student in Pennsylvania to attend Penn State?
It's extremely high. The average four-year tuition for a public university in Pennsylvania is the third highest in the country, after only Vermont and New Hampshire. So you're absolutely right. The cost is far too high. I think it's about $30,000 or $27,000.
So just tuition and fees. Before we get into living expenses, tuition and fees on the website, $18,454. Mr. Sanders, do you know the cost of in-state tuition for a student at the University of Illinois at Urbana?
I don't know the answer off the top of my head.
The tuition and fees is roughly, they estimated, it's $16,000 to $21,000, depending on exactly what school you're in. If you look at what's going on in Massachusetts, Ms. Darkus or Ms. Thomas, do you know the cost for an in-state student to attend UMass Amherst for an in-state student?
I believe it's around $20,000.
On the website for an in-state student, tuition and fees, before we get into housing and living expenses, $15,887. Before I came to Congress, I served on the University of Wisconsin Board of Regents. To attend the University of Wisconsin-Madison, the flagship in the state, tuition and fees, $10,555. Significantly less than your three states. What did we see last year in the state of Wisconsin for overall debt? It decreased. Why? Because we're controlling the underlying cost of the product. That is absolutely critical. And when states are able to control the underlying cost of their tuition, in particular for in-state students, you legislate that ability to control the cost, and you have a real impact on students' borrowing rates. But when you can't legislate, you litigate. And what we're seeing is states with high costs of in-state tuition, where they're having high costs of student debt, then trying to go out and litigate their way politically out of the problem, rather than addressing the underlying cost structure that we're placing on students. So at the University of Wisconsin system, where I was a regent, what we did is we held the line on tuition. So dollar for the last 6 years in the state of Wisconsin, the cost of tuition to attend the University of Wisconsin-Madison, the University of Wisconsin-Whitewater, University of Wisconsin-Parkside, or any of the campuses in the entire state of Wisconsin in the UW system was flat, dollar for dollar. What does that do? That actually drives down the cost of tuition against inflation and makes college more affordable and actually reduces the total debt burden that students are taking out. And so when you can't legislate that in, we take this litigation path to go after and to try to find out where are there these disruptions in the market. And I'm very open-minded to trying to find opportunities to improve the process. One of the things I think would be interesting is, do any of you, by a show of hands, answer calls that come to your cell phone from an unknown number? May the record state, no one raised their hand. Including myself, I don't answer the phone from an unknown number. If it's a known number, I'm happy to pick up. If it's an unknown number, I usually let it go. If we look at our federal law, that the student the student loan services are obligated to operate under, they can't text you, they can't do all this modern mechanism to let people know that they might be late. There's real opportunities for us to explore real solutions to the problem, to, God forbid, legislate rather than litigate the problem. I know Mr. Buchanan's had a number of items where you've identified ways to improve the process, to legislate an improvement, rather than to drive forward a litigation approach where, one, the states are unable or unwilling to control the underlying cost of the product, and then two, we're holding hearings on the litigation side rather than sitting down and looking for significant improvements on ways that we can actually be productive in collecting the student debt, and then on a go-forward basis, how we actually control the underlying cost of the product, which will have a real impact on students who don't need to take out the debt in the first place. I appreciate the time. Thank you very much. I yield back.
Gentleman yields back. I'll recognize myself for 5 minutes. Mr. Stiles makes some very good points about the costs going in. In Colorado, our tuition is $12,000, so not much more than yours. Managed it fairly well, but he started at the beginning of the process. I'm going to go to the end of the process. Ms. Thomas, in your opening, you talked about non-dischargeability of the debt. And I practiced bankruptcy for a long time before I got here, generally representing the creditor side. In fact, I represented one of the lenders who was mentioned by Mr. Lynch, FIA, Pennsylvania Higher Education Assistance Authority, on these kinds of things. One of the things that happened that dramatically changed, I think, the landscape was to make these student loans almost impossible to discharge. And if I'm not mistaken, we've seen the balloon in the student debt since that time in 2005. Can you talk to me, and Mr. Buchanan, I want you to jump in on this too. I mean, what would be the effect generally on the system if we allowed these debts to be discharged?
I think it would be positive for many participants in the system. There are many borrowers who have been victimized by schools who are simply in no position to repay these debts and are often in no position to navigate these more complicated income-driven repayment plans and the associated processes.
Mr. Stiles talked about why we immediately go to litigation, but sometimes you can't, there's no way to get out of this, and you take a drastic remedy of bankruptcy. It's not, people don't do this lightly. I mean, so Mr. Buchanan, if we in the Congress, because we changed the law in 2005, if we were to reinstate what it was pre-2005, what effect do you think that would have on the market generally? Because the comments I've heard is that it would cause the rates to go up. I mean, how does the association look at it?
So again, we're on the servicing side, so we're not on the lending side, and the federal government owns the asset. So the cost of bankruptcy dischargeability is borne by the federal government under a federal loan. So I think that's a question of, does the federal government, from a cost perspective, think that's an appropriate subsidy or benefit to provide to the loan?
Well, and the reason I even bring this back up is because we've tried a number of different paths, you know, forbearance and reducing interest rates and providing credits for service rendered by public employees. I mean, we've come up with a dozen different things to try to reduce what seems to be just this dramatic increase in student debt in America. So, as servicers, I assume that you have thought about what happened if Congress, you know, changed it back. What's been your view of it?
Yeah, I think that would be something that, listen, I think there's a lot of borrowers who get into distress. And at the end of the day, we're trying to say, if someone has an option, what is the best option for them? And I think, you know, looking at an appropriate sort of assessment of bankruptcy reform is always something that should be on the table. And you highlight, though, the evolution over time, and that's sort of, I think, where Congress is sort of, you know, prior to 2002, forbearance was a process that had to have written documentation, and then negotiated rulemaking with servicers, the National Consumer Law Center all agreed, let's make it far easier to do verbal forbearance. So those things need to evolve over time as we identify pockets of individuals who are not being best served by the current system. But that's also a function of time, because the amount of people, the people who are going into higher education, I mean, the great success of putting more and more individuals that historically were prevented from getting access to higher education means we need to change the process constantly. And that's where we're, you know, in always looking to share that information with our regulators, Department of Education, and I'm sure they'll share it with you about things we can do to improve.
Just, Mr. Smith, so staying on the same theme, and I got about 30 seconds. I mean, the law says to discharge requires undue hardship. And I remember FIA was pretty tough on what undue hardship meant as we would proceed through the bankruptcy court. Has that changed? I mean, you don't represent FIA, you're with the Attorney General's office, but how do you guys look at that?
Yeah, I definitely can't speak for FIA, but I think undue hardship is far too high a line, and we should certainly consider allowing student loans, both private and federal, to be dischargeable in bankruptcy.
Thank you, and my time has expired. I recognize Ms. Dean for 5 minutes.
Thank you, Mr. Chairman. I'm pleased to be here for hearing all of your testimony on this important issue. And I want to just say at the outset, I look through a couple of lenses, and one is as a mom, a parent, and a grandparent to college-educated kids and hopefully college-educated grandchildren. I'm also a former university professor for 10 years in Philadelphia. I'm also a former state legislator who dealt with the issue of higher education funding. And I just want to say, in response to some of the testimony or questioning or statements from the other side, this is not an either-or situation. We can agree that the cost of education is extraordinarily high in this country, and we can agree that we should do something about that, regardless of where we find that funding. But it's not either-or. So I'm puzzled by the lack of curiosity by those on the other side of the aisle who only want to speak about that as though there is no possibility of harm to consumers on the other side. So that's where I want to start. First of all, Mr. Smith, and I really appreciate, I come from Pennsylvania, as you know. I really appreciate the work of our Attorney General, Josh Shapiro, and what he is doing to protect borrowers, consumers at many levels. Would you help me with the scope of the problem? In your testimony, you identify that Navient, between 2010 and 2015, enrolled over 1.5 million borrowers in 2 or more consecutive forbearances. Their own numbers show that these forbearances added nearly $4 billion in interest to those consumers. Is that Pennsylvania borrowers only?
That's nationwide.
Nationwide. $4 billion. Can you specifically show how that direct harm happens? What was the practice that led to that massive harm to consumers? Direct, dollar-for-dollar harm to consumers, not to mention credit ratings and other anxiety and everything else that goes along with that.
Sure, so that's, that $4 billion in extra interest comes from multiple consecutive forbearances. So we've been talking a lot about forbearances and how they can be harmful. There are occasions when somebody may truly have a short-term need. Say they lose a job, but they know they're starting another job in 2 months, and they'll be making enough money then to go back to their standard repayment plan. In that case, perhaps a fair forbearance makes sense for a couple of months.
Sure.
But we're talking about multiple consecutive forbearance where people are in forbearance for 12 months, 18 months. We've even seen people in forbearance for 3 or 4 years. And at that point, there's no way that the servicer can argue that this borrower is in short-term financial distress. They're in long-term distress, and they should have been put into an income-driven repayment plan much earlier in the process, if not at the very beginning. So that 1.5 million borrowers who were in 2 or more consecutive forbearances, they had $4 billion in extra interest added to their loan principal as a result of those forbearances.
Were they given clear notice that by doing this over and over again, you're just adding to your interest? I mean, clear notice, plain English notice.
So I can't speak to every single one of them, but as I said, I think certainly at the end of the first forbearance, they would have had to talk to Navient again, and Navient would have said, okay, let's put you into another forbearance. Is that okay? And we have found through reviewing call recordings and in our investigation that Navient often did not mention income-driven repayment plans at all.
Right.
And sometimes they'd mention it in a very cursory way without properly explaining it to the borrower.
In your complaint, in the Pennsylvania complaint, it's alleged that Navient and its agents were incentivized to push forbearances instead of IDR. Can you explain that?
Sure. So Navient mentioned average call time for their agents at their call centers, and they rewarded people with bonuses for keeping their average call time low, among other metrics.
What kind of bonuses?
A couple $100, gift certificates, that sort of thing.
And if I interrupted you, was there more to that practice?
There's actually a really good podcast. Michael Lewis did a podcast about this where he interviewed a woman who worked at the call center in Wilkes-Barre, Pennsylvania, and she described the 7-minute rule, where basically you were expected to get off the phone with the borrower in 7 minutes. And if you did a forbearance, you could achieve that goal. But if you started talking to the borrower about IDR, there was no way you were going to meet that metric. And Navient would eventually fire you if your average call times were too high. So the people serving the borrowers well were being pushed out the door, and the agents who were doing a bad job and hanging up on borrowers and not telling them about IDR were promoted and rewarded.
Again, I just am puzzled that the other side isn't curious or upset about $2,700 per borrower added to the
Gentlelady's time has
Thank
expired.
Thank you, Mr. Chairman.
The chair will now recognize the ranking member of the subcommittee for unanimous consent.
Thank you, Mr. Chairman. I would ask unanimous consent that we enter into the record 4 articles. One from the Consumer Bankers Association that reports 98% of private student loan borrowers are successfully repaying loans, whereas 1 in 5 federal student loan borrowers are seriously delinquent or in default. A second letter from the Credit Union National Association urging attention to the benefits to borrowers through more private loans. A Wall Street Journal article reporting that despite the CFPB's allegation that Navient had a profit motive to place borrowers into forbearance, in fact, Department of Education pays loan servicers 63% less for accounts in forbearance than those in income-based plans. And finally, an article that reports that despite the CFPB lawsuit, Navient, in fact, informed borrowers about income-based repayments, but borrowers opted for forbearance regardless.
Without objection, they will be so admitted. The chair now recognizes the gentlewoman from California, Ms. Porter, for 5 minutes.
Thank you. Mr. Buchanan, do servicers act in the best interests of consumers?
We absolutely work every day to provide them all the options that are available to them. And those options, what is best for them is really a choice among consumers, because at the end of the day, each of those options is going to have a different consequence depending upon what job they take, what life choices they make.
I just want to stop you. So servicers act in the best interests of consumers. So Navient, your former employer, member of the organization that you're here to represent today, is arguing in court that there is no expectation that the servicer will act in the interest of the consumer. Did I mishear you?
So are you asking a question about the legal definition of fiduciary duty?
No, I asked you a question. I asked you if servicers act in the best interest of consumers, and you said, and I quote from 10 seconds ago, yes. I am now reading to you from arguments that Navient is making in court. Quote, there is no expectation, no, the opposite of yes, there is no expectation that the servicer will act in the interest of the consumer, and further, servicers do, quote, do not owe borrowers any specific fiduciary duties based upon their servicer-borrower relationship. Would you like to revise your prior answer to the question I started with? Do servicers act in the best interests of the consumer?
So servicers work for the government to provide the options that are available, and we disclose them clearly. We disclose them.
I'm asking you.
We don't make the choice of what we're paying.
I'm reclaiming my time, please. I'm going to ask the question again. Do servicers act in the best interests of consumers?
I believe by executing what we're asked to do by the federal government, if that is what is in the best interest of students, then that's what we do. So
you act in the best interests of the government, which you believe to be in the best interest of
consumers. We work
consumers.
for the government. That is correct.
Okay. So, Mr. Buchanan, I read your testimony, and in it, I understood you to say, quote, you're proud of your work. You're proud to talk about the success that in making a difference for consumers. So I wanted to try to summarize and get a handle on your some other statements and make sure I understand your testimony. Would you agree or disagree that recent media reports about servicing are inaccurate and that those claims are counter to the commitment of servicers to help borrowers?
I believe there's a lot of rhetoric that has mischaracterized pretty meaningfully what we do and the performance of what we've achieved, yes. I think we'd like to talk about sort of those success rates of improving IDR and other things that have been
reclaiming my time. Yeah. Would you agree that you expect your lawyers to follow all laws, regulations, and individual rules and policies, and you expect your lawyers to follow the laws?
Well, I don't have any lawyers myself, but if you mean sort of the legal departments of servicers, I think that's the expectation, and we do comply with the federal law that's applicable here.
Okay. Would you agree that servicers have been accused, including by some of the other witnesses, of intentionally assessing inappropriate fees and costs to borrowers?
I believe there have been assertions. I mean, I don't think they've asserted fees.
Is it your would you agree that those allegations are not true?
I'm sorry, repeat the question.
Would you agree that those allegations are simply not true?
I don't believe the facts are consistent with those allegations as best I've seen. But again, I'm not privy to the litigation here, so there may be facts I'm unaware of, but all evidence and all performance metrics from a servicer perspective to the contrary.
Mr. Buchanan, I'm running out of time. With apologies to Brandi Carlile, my favorite artist, I have been to this movie and I've seen how it ends, and the joke is on them, the American people. The statements that I just read to you are all from the testimony of Countrywide during the mortgage crisis. When I sat where these folks sit as a witness and listened to the witness from Countrywide say that the media reports are inaccurate, that they expect their lawyers to follow the law, that there have not been an intentional assessment of inappropriate fees and costs. So I already have Netflix. I don't need another crappy reboot. These are the exact same arguments that we've heard before. You sound just like Mr. Mozillo, and you're doing the same exact kind of harm to our economy. Thank you.
Gentlelady's time has expired. The chair now recognizes the gentlewoman from Massachusetts, Ms. Presley, for 5 minutes.
Thank you, Mr. Chairman, and thank you for this critically important conversation this morning. And I want to thank our witnesses for joining us today and recognize Ms. Thomas and Ms. Darkus for your work on behalf of struggling student loan borrowers throughout the Commonwealth. The testimony shared today underscores the severity of the student debt crisis taking place in our country This crisis has placed an unprecedented financial burden and caused a tsunami of hurt on an entire generation of young people, hindering their ability to purchase homes, start a family, and even to save for retirement. Across the Commonwealth of Massachusetts, more than 855,000 borrowers owe $33 billion in student debt. Last year alone, student loan debt in Massachusetts increased by $1 billion. Despite the fact that this crisis has reached record proportions, this administration has either failed to act or has intentionally worked to undermine state efforts to protect borrowers. Back in March, I asked CFPB Director Kraninger if she believed that there was a student debt crisis in our country. She refused to answer my question, a shocking but not surprising response from the person running the sole agency charged with protecting student loan borrowers in the financial marketplace. So I'm glad to be at this hearing to talk about the steps that state policymakers and state attorney generals have made to protect borrowers. The student debt crisis is a racial and economic justice issue as well. Ms. Darkus, tackling student debt is both a racial and economic justice issue, so how is student debt exacerbating the racial and gender wealth gap?
We see that in order to afford a college education these days, people of color disproportionately rely on debt to make it through. So when we look at what's happening in repayment, it's disheartening to see that the very same people who are trying to take advantage of the promise of education to achieve better economic outcomes for their families, to experience the economic mobility that education is supposed to promise, end up getting bogged down. The cost of that education increase through servicer misconduct and error, and they disproportionately experience default. And since women bear so much student loan debt, we're also cognizant that they carry a special burden, and we should be looking out for outcomes based on gender in repayment as well.
Okay, so picking up on that, so federal student loan borrowers have a right, all of them, to an affordable monthly payment regardless of their loan balance through income-driven repayment or IDR, correct?
Yes.
Okay, but research has shown that when a borrower is able to get into and stay in an IDR plan, she is significantly less likely to default on her student loan, correct?
Yes.
Okay, so despite the fact that federal student loan borrowers have a right to an affordable payment, research has shown that Black and Latinx borrowers face significantly more challenges as they try to access these repayment plans. So this reflects many of the disparate impact trends we see in mortgage redlining abuses. Ms. Darkus, can you share some of the real-world consequences when a low-income borrower falls into default?
Unfortunately, the default triggers a world of hurt for clients like mine, many of whom are people of color and women. They can have their wages garnished, they can have their tax refunds, including the earned income tax credit, seized. And what we end up seeing is that the limited income and wealth that exists in communities of color gets siphoned off through these government debt collection activities, and that means that the racial wealth gap is growing due to student loans.
Okay, then. So do you believe this is evidence of potential discriminatory behavior or misconduct in the student loan market?
We definitely have to look at the disparate impact in student loan outcomes based on race and gender. And so we've got to look at, is discrimination happening in servicing, because the outcomes are stark. People of color fare worse.
All right, thank you. Mr. Thomas, the Massachusetts AG's office under the leadership of Attorney General Maura Healey has worked diligently to increase oversight over these servicers. In 2017, your office brought a suit against the Pennsylvania Higher Education Assistance Agency, or PHEA, for their egregious servicing failures that ultimately caused many borrowers to lose eligibility for the Public Service Loan Forgiveness Program. Can you briefly explain the major findings of your case? I'm sorry, Mr.
Our allegations include that PHEA has denied borrowers the opportunity to make qualifying payments for public service loan forgiveness and income-driven repayment forgiveness by failing to properly and timely process applications for income-driven repayment plans. We have also alleged that the company failed to properly count borrowers' public service loan forgiveness qualifying payments. Further, we have alleged that they have failed to properly process Teach Grant certification forms, leading grants that were given to teachers to be converted to loans. Finally, we have alleged that FIA has collected amounts not legitimately due and owing and failing to refund them to borrowers.
The gentlelady's time has expired.
Thank you, Mr. Chairman. Thank you.
The chair now recognizes himself for 5 minutes. Ms. Darkus, is it true that the Department of Education is withholding information and encouraging others to withhold information that is relevant and is, in fact, being done to the detriment of the borrowers?
Those are the reports that I have heard, and you've heard testimony today from Mr. Smith, for instance, who explained that their work in the Navient case has been held up by the department's efforts to prevent the servicer from disclosing important information.
Thank you. Mr. Smith, would you care to comment, please?
Yes, the Department of Education is telling servicers not to turn over information regarding federal loans, and that is hampering our efforts and the efforts of other states.
Well, you know, I regret to see this happening, but it does not surprise me, given that the Trump administration, by and through the president himself, refuses to honor subpoenas, refuses to encourage witnesses to testify, and in fact, encourages witnesses not to testify. It seems that the Trump cover-up mentality is permeating other areas of the government to the extent that consumers are going to be harmed. Regrettably, this mentality is something that we will have great difficulty dealing with unless we decide that we're going to deal with the chief executive officer, who is the chief sponsor of the cover-up mentality. Let's move on. There have been those today who seem to think that poor people, many of whom happen to be people of color, make bad decisions when they acquire loans. Is it true that most poor people need the loans to get the education so as to extricate themselves from the adversities of poverty? Mr. Smith, would you care to comment?
It's true that poor people, if they wish to attend college, must take out loans because generally their families have very little savings to help with college, and state legislatures have reduced the amount of money that they've put into the public university systems over the past decade. So families are having to borrow more now than they ever have before.
Thank you. Ms. Darkus, is it true that if you're poor and the loan is the only option for you and the amount is what's necessary for you to get an education, that you really don't have any option other than to take out the loan? What other options do people with little wealth have?
You're right to point out that these aren't really good choices, debt or education. You have to get both in order to get either at this point. So while we're financing higher education through debt, it's not surprising that the people who have the least means rely on that debt more. We need a system where we're not relying on people who have very little to take on the most in order to get the education that they seek.
I heard a colleague across the aisle indicate that we should get to the root of the problem. Well, the root of the problem doesn't start with the birth of a poor person today. It doesn't start with the adversities that they encounter today. They start with a system of systemic discrimination, invidious discrimination, that has been in place in this country from its inception. If you differ with me, kindly raise your hand. Let the record reflect that we have no hands raised, and the chair concludes that the comment made is correct. If we want to truly get to the root of the problem, is it fair to say that we have to deal with systemic, invidious discrimination? If you agree, kindly extend a hand into the air. Let the record reflect that all have extended hands into the air. And let the record further reflect that my time has expired, but my desire to end invidious discrimination will only expire when I expire. I want to thank the witnesses for their testimony and for devoting the time and resources to travel here and share their expertise with this subcommittee. Your testimony today has helped to advance the important work of providing meaningful oversight of the CFPB and student loan servicing industry. The chair notes that some members may have additional questions for the panel, which they may wish to submit in writing. Without objection, the hearing record will remain open for 5 legislative days for members to submit written questions to these witnesses and to place their responses in the record. Also, without objection, members will have 5 legislative days to submit extraneous materials to the chair for inclusion in the record. Without objection, the hearing is now adjourned. If you'll wait for just a moment, witnesses, I want to come down and thank each of you before you leave, witnesses, so please don't exit.